SJC-11714, Commonwealth v. Juan Pagan.
Thank you.
Morning, Your Honors.
Good morning.
May it please the Court, my name is John F. Palmer. I represent Juan Pagan, who is the appellant on two issues and the appellee on one issue. The first two issues that were raised by the appellant, number one, I'm not going to argue or spend any time on. It involves the public trial right that was allegedly, according to us, violated. This Court's decision in LaChance essentially forecloses that argument, but I want to preserve it for whatever federal remedies may be available later on. The second point that I am raising is the trial judge's failure to give a lesser included instruction of involuntary manslaughter under the facts of this case. The issue raised by the Commonwealth having to do with the judge's reduction of the verdict from murder 1 to murder 2 under authority of 25, B2, I will address briefly as well. This was a case that was indicted as a first-degree murder case, and the judge, as I said, reduced the verdict to murder 2. The circumstances, the facts at trial indicated that there were a group of people, young juveniles essentially, at a house where the defendant was residing. The victim of the case had come to that house and was very upset and angry at a group of people called the Grips. There was some evidence at trial that he associated the defendant, Juan Pagan, as either knowing Grips or being a Grip. It's a little bit ambiguous. In any event,
Is that a typo? Is it Grips?
No.
Or is that meant to be Grips?
It's meant to be Grips.
Meant to be Grips, okay.
It
has to do with housing, doesn't it?
Pardon?
Isn't it a group that people, homeless,
right.
Yeah.
It was a group of people that...
had a grip on the Crips.
In any event, it wasn't really a gang association, but there's some evidence that somehow the victim associated it with gang activity. And whether, I don't think the evidence indicated that the defendant was actually a member of the Grips, but there was some indication that that's what the victim thought. In any event, there was, the victim came to this house where the defendant was residing and was angry, upset, agitated, and there was some evidence that at least one witness observed that he may have had a gun. He patted his waist as if he did have a gun and mentioned something about shooting Grips, or the people who were responsible for beating up his friend. The evidence, there were 4 witnesses who testified, juveniles who were at the house that night. They essentially, up until the immediate time frame leading up to the stabbing, their testimony was that the defendant left the house at some point. And at that point, he went out and he saw that the car windows to his father's car had been shot out. And so the defendant became upset and angry because he related that shooting incident to the victim's earlier threats and thought the victim was responsible for shooting out the car windows. In any event, the defendant then went over to a friend's house and explained the situation to the friend. He asked the friend if he would help him out. I think the words were, would he come and watch his back if he came back to the house? The friend declined to do that, The defendant went back to the house and sat or lay on a mattress, and then the testimony becomes a little ambiguous from the four people who were there. There was testimony from the one witness, which the judge cited in reducing the verdict, that he patted his side, his waist, and said he had a gun. And essentially, this was interpreted by the defendant as a threat to kill him.
I take it the jury was instructed on self-defense, excessive force in self-defense.
The defendant, the judge
Heat
did
of passion
instruct.
as well? Heat of passion?
Heat of passion.
Well, reasonable provocation, wasn't it?
Pardon?
Yeah, reasonable provocation.
Reasonable provocation.
That's what I meant.
Right. So all of those instructions were given. The one instruction that was not given, and just to complete the factual scenario, so the testimony from the expert, there was an expert testifying on mental impairment, and the defendant suffered from attention deficit hyperactive disorder. Not that uncommon, but it has certain attributes to it that cause this individual to act impulsively, without thought, and that sort of thing.
And these issues were plainly before the jury.
And the issues were before, exactly, the issue was before the jury. The issue of the defendant's youth, which also the judge cited in the 25B2 motion, very presciently, I would suggest, in light of what's happened in subsequent jurisprudence in this court, in the U.S. Supreme Court, talking about the lack of development of a juvenile mind, adolescent mind of a 16-year-old, and that type of thing. So all of the instructions that Judge Cordy mentioned were given. What was not given, and the psychiatrist or psychologist also testified that the defendant, in her interview of the defendant, had given his version of events as he perceived them. And in his version of events, he said, first of all, that he thought that the victim had a gun, which was reasonably corroborated by other evidence in the case. He also said that when he actually stabbed the victim, he blanked out. And then later he said he was fearful that the victim might shoot him.
Did that come in for all purposes, or was that in for the basis of the opinion?
It came in for all purposes.
Wasn't entitled to.
Maybe not, but it was the law of the case. I mean, it came in as a statement. So
I guess the core issue here is, if we were to find that what the judge really did here was to say the evidence of premeditation was pretty slim, I think that's the word she used. Right. This is a kid who was a juvenile at the time and had various issues which meant that he was going to be impulsive, and I just don't think it's appropriate to give him a sentence which would mean he would have no possibility of parole. So I'm going to drop it to second degree, because at that time that was the only way to accomplish that result. If we determine that that's what the judge really did, do we affirm?
Well, I think that the judge, I don't think that's what the judge did. I think the judge clearly was aware of the Lyons case, which was the latest, not the latest, but it was a case that had just come out in which this court had reversed a trial judge's allowance of a reduction. And she was aware of that case, and she tracked her opinion to the requirements of that case and other cases that suggest that if you're going to reduce a verdict on a 25B2, you have to focus on the evidence at trial if you're reducing it from a premeditated to first degree to second degree. And she did that. If you look at her opinion, she addresses all of the factors which this court has addressed in either exercising its authority under 278-33E or in reviewing a reduction under 25B2. So in response to your questions, that's not what she did. As a matter of fact, she didn't, I don't think in her opinion she even addresses that point, the point that you mentioned that, well, and I know, you know, it begs...
The evidence to be sufficient as a matter of law.
Correct.
But basically slim as to premeditation, sufficiently slim that she thought that a second degree was more consonant with justice.
Correct.
And of course, she would have known that second degree meant you had the possibility of parole. Is there anything wrong with that?
I think that, well, I think the focus, that can be probably one of the considerations, but it cannot be the determining consideration, because this court in Lyons said, and also, unfortunately, in the Roland case, which was my case, one of the few cases, 3 or 4 cases in which this court has reversed a trial judge's exercise of discretion. But this judge focused on the factors and the evidence at the trial. And part of that, the distinguishing factor here about the mental illness is that mental illness or the mental impairment was an evidentiary factor at trial, and it related directly to the element of premeditation, unlike cases where the Roland case or the Lyons case, where the court thought that the trial judge was relying too much on personal factors unrelated to the evidence at trial or the elements of the offense. So, but I wanted to quickly get back to the lesser included argument that, so there was, I mean, it's black letter law that if there's any evidence, no matter how credible or incredible the judge or anyone else may consider it to be, if there's any evidence in the record that, if believed, would warrant a lesser included instruction, the instruction must be given. And in this case, the facts are very similar to Commonwealth versus Gray, where you had an individual, 15-year-old boy in Gray, who had paranoid traits. He had a borderline intelligence. There were psychiatrists who testified at the trial. The evidence was that he was playing around with a switchblade on a street corner in a park. And while he was playing away, he felt fearful of these individuals who were surrounding him, and he thought that they might steal his paycheck. The evidence from the Commonwealth was that as the victim in Gray moved away, the defendant, Gray, took the switchblade, opened it up, and stabbed him, went toward him and stabbed him so he couldn't get away, killing him with that one stab wound. And on those facts, and the defendant, Gray, testified that he didn't realize that the weapon was not open, or that he wasn't sure that what he was doing was stabbing.
But you don't have that here. You've got an 8-inch combat knife, which is thrust the full length of the knife into the guy's chest. So how can a reasonable jury say that that person who did that did not intend grievous bodily harm, or that a reasonable person would not see a plain likelihood of death arising from an 8-inch thrust into the abdomen with a combat knife?
Because of the evidence from the defendant that he blanked out. I mean, there's no difference. I mean, the Commonwealth...
They blanked out before or after?
At the time. In other words, the testimony...
He said that at the time, he said that he blanked out before he thrust the knife into his chest?
He told the expert that he blanked out during the sequence of events that involving the stabbing itself. It's absolutely indistinguishable from gray. To say that suggest there's a difference between, a switchblade going into one's heart and the knife in this case is really a distinction without a difference. Because all of the cases that talk about, well, the use of a knife precludes an involuntary murder instruction are not applicable to the situation that existed here. It is true if you knew you were stabbing somebody with a knife in the chest, then those cases would apply. But one quick cite that I did not give to the court on the issue of, unfortunately, I can't get into all of the issues surrounding whether or not an unlawful killing without malice is murder, is manslaughter, independent of the requirements of involuntary manslaughter. But I did want to give to the court one cite, Commonwealth versus Martinez, 393 Mass 612. This deals with the issue the Commonwealth has suggested that this, even if it was error not to give an involuntary manslaughter instruction, it's harmless error, suggesting that the jury found that there was first-prong premeditated malice, so it didn't make any difference that no lesser included instruction on involuntary manslaughter was given. Black letter law is, if you don't give a lesser included offense, it's reversible error. Martinez was a first-degree murder case, premeditated murder, jury convicted of premeditated murder, failure to give involuntary manslaughter instruction was reversible error. Thank you.
Thank you.
Welcome back.
Good morning again, Your Honors. May it please the Court, Assistant District Attorney Bethany Stevens from Middlesex on behalf of the Commonwealth. With respect to the involuntary manslaughter instruction, I would suggest that the fact that the jury found that the defendant had a specific intent to kill, a verdict of premeditation, forecloses the conclusion that there could be any reasonable interpretation of the evidence that the defendant did not know what he was doing at the time. The defense expert does not support a finding that the defendant wasn't able to appreciate that he was stabbing the victim with an 8-inch combat knife. It was her opinion that he didn't think at all, and the reason she said that is because he was impulsive, based on his statements to her, that he was reacting impulsively because he thought the victim was going to kill him. There's nothing in that testimony that suggests that he did not realize that he was stabbing the victim with an 8-inch combat knife. And I did file a motion to transmit the exhibit. I do have a picture of the knife in the Commonwealth's brief. It does not give the knife justice. If you see it for yourself, there is no doubt and there is no evidence that would support giving an involuntary manslaughter instruction in this case. And if there aren't any other questions, I'd rest on my brief with respect to that argument and focus instead on the Commonwealth's appeal of the 25B2 reduction. Your Honors, the verdict here was not against the weight of the evidence. The judge's decision here was based on 4 factors. She found that none of these factors alone would warrant reducing the verdict, instead finding it was the combination of the 4 factors. One of those factors was that he had ADHD and his limited cognitive capacity because of his age. It's very important to consider, though, is that in the defendant's expert's opinion, her testimony was clear that it was not just ADHD and age alone, but it was those things factored with the belief that the victim was going to kill the defendant. And the only evidence that the victim was going to kill the defendant is the defendant's statements to the expert. That is a hearsay basis, and while the jury was allowed to consider it in their consideration of the evidence, it's the Commonwealth's position that that's an improper basis for the judge to nullify the jury's verdict, essentially crediting the hearsay statements of the defendant over the eyewitness testimony that said that there was no threat to the defendant that night. With respect to the facts of the case, I do want to make clear there was a typo in the transcript. There was 2 types of groups going on. There was the GRIP group, G-R-I-P, which was the homeless housing place where Stephen Pettles was associated with. I think Brian Murphy lived there and Markeem lived there. But there was also Alex, the victim, was upset about his friends being jumped by members of a gang, and that gang was the hostile Crip takeovers. Ray Normal testified to that he and Stephen Pettles, associated with members of the hostile Crip takeovers, went to parties, and that there was some belief that Juan might have associated with them as well. But importantly, this was not the defendant only being a gang member and the victim being upset with the defendant and gang members he associated with. There was 2 other people associated with the defendant, with the gang, with the Crip takeovers. This is Ray Normal, who was there and testified, and he testified that there was no threat to anybody in that apartment that night. And Josh Apostolos, he was the one that was sitting next to the defendant on the mattress. And I put in my SRA is a copy of Exhibit, I think it's 24. And that is the layout of the apartment, of where everybody was. The door is over here. The defendant is sitting on this mattress here. So there's talk that there's people in the kitchen who see the defendant or the victim in the doorway. Josh Apostolos is the only one who sees this padding of the waist. There's no gun shown. There's a padding of the waist. There's a question about, is that real? And the defendant asks the victim, while twirling the combat knife, is that real? Are you ready to use it? In a tauntingly way is how he described it. And the victim responded, yes. Then the testimony from Josh Apostolos, the only one who saw this padding of the waist, says that the victim then talks to somebody in the kitchen. And then when he turns around is when the defendant jumps up and drives the knife into him. I agree, it was surprising. It was but it was the defendant taking the victim by surprise, not reacting impulsively to something that the victim did.
In the reply brief, the defendant says that Apostolos acknowledged that when he was asked in the grand jury if Alex had threatened the defendant, he stated that there was a threat where he said he had the gun on him.
Right, and so that was, and he just cites to the cross-examination. On redirect, the prosecutor asks him, let me ask you the next question in the grand jury testimony. Was he threatening to use it? Answer, not to use it on anyone there, just in general. He was upset at the people who jumped his buddy? Correct. Did he even make a threat to anyone who was in the apartment? No, not at all. So in the grand jury, he did say that, was there any threat that night? The general reference of this gun, of padding his waist, but it wasn't directed to anybody in that apartment. Ray Normal, who was associated with this hostile Crip takeovers, he said that what had happened was that the victim was actually getting ready to leave, came over and got a cigarette from him. Ray Normal was sitting on the ottoman. I had that correctly in my statement of facts. I think in my argument I had him in the kitchen, but his testimony at volume 352 is that he was sitting on the ottoman, and that the victim came over to him to get a cigarette and was turning around to leave. And it was at that point that the defendant jumped up and thrust the knife into him. So I would suggest that on the basis of unlike other cases where a reduction has been warranted because there is an inexplicable reason, because there aren't any eyewitnesses, in certain circumstances, I think in the McDermott case, where the court found that there were no eyewitnesses and all we had was the defendant's version, but it was the defendant who actually testified there, as opposed to statements that came in through the expert. And I would suggest...
Saying that the judge should have disregarded what the expert said she had been told?
I would correct, Your Honor. I would say that it's not an appropriate basis to nullify the jury's verdict based on the statements by the defendant to the expert. And the expert was clear that her opinion of impulsivity was based on crediting this threat, that he believed he was going to be killed.
But this evidence came in for all purposes, whether it should have or not.
I agree with Your Honor, and I think that it's,
So it was okay for the jury to consider it, but not okay for the judge to consider it. On what do you base that?
I would just suggest that the defendant essentially got more than he was entitled to.
Is there a case that says that the judge couldn't do that?
I guess I would say that the standard in terms of a 25B2 is whether whether you have a belief that the verdict is not based on a careful consideration of the evidence, but it was a product of bias, misapprehension, or prejudice, and to find that there was an incorrect balancing by the jury by finding contrary evidence based on this hearsay statement where there was eyewitness testimony.
Well, it's not just bias, misapprehension. I mean, isn't it basically like a substantial, isn't it like a 33E?
In the Commonwealth versus Jefferson case, which this court recently cited approvingly in Commonwealth versus Ortiz, it does use that language. It must appear that if the verdict were allowed to stand, it would work a miscarriage of justice. It's not enough that the judge felt a reasonable doubt that the jury did not share. And the court recognizes, too, that there is a public interest in sparingly using this power because the participants at the trial here, the victim's family, who heard the jury instructed on every possible mitigating circumstances, that the defendant got the benefit of every possible benefit of the doubt, I guess you could say, and that the jury carefully considered the evidence and came back finding that this was a decision. I recognize that there are circumstances that would find that this is a bad decision, but it's a decision nonetheless, and that's what premeditation is about. Was there a decision to kill? And that's what the jury came back with. So I would suggest that, and going back to what the four factors that the judge relied on, so it's the Commonwealth's contention that she can't consider the ADHD and youth where the evidence at trial was that it was only that coupled with the threat that he was going to be killed, and there is no other evidence of that. The personal circumstances alone, I would suggest, is an improper basis to reduce the verdict, and that only leaves the fact that there wasn't that the knife was already in the apartment and the victim was already in the apartment, that he wasn't seeking that out. And I think the best case that I have on that would be the I think it's the Garabedian case. Where, yes, the Garabedian case that's cited in my brief, and there the court found that in that situation the defendant did not bring a weapon to the scene, did not go there with a murderous intent, but still distinguished it from cases that have been proper to reduce the verdict, where the instigator wasn't the defendant wasn't the instigator of the conflict, wasn't the initiator of the physical contact, or cases where that falls into this senseless encounters.
The trial judge didn't reduce the verdict in Garabedian.
I'm sorry?
The trial judge didn't reduce the verdict in Garabedian, did the judge?
And I think this was more on the 33E, I think, but it is the same standard, and so the court in declining to reduce it under 33E. And I would just get to that point there and saying that, the Commonwealth, I know that there's language saying about that the trial judge should be afforded more discretion because they have been there, and recognizing the dissent in Lyons on that point. But I would just suggest that this extraordinary power that to a certain extent starts to infringe on the legislative prerogative of defining the substance of the substantive crimes and the penalties, that this authority was given from the legislature to this court. And it's because this court, the purpose of the power is to survey the cases and to make sure that all first-degree murders are consonant with justice. And it's this court that actually sees all first-degree murder cases, not the trial judge. And to suggest that we should be giving more deference to the trial judge because they were there and saw the evidence really starts to encourage a judge sitting as a 13th juror, which the case law is clear that that's not the case. Now, I understand that if the defendant had actually testified and the judge made a credibility determination based on weighing that evidence, we might be in a different place, but it's the Commonwealth's contention that there is a difference here where the only way to find this spontaneity, this impulsivity, is to believe that the victim was threatened at the time and responded that way, and the only evidence of that is based on the hearsay statements offered through the expert. So it's for these reasons that we would ask the court to consider reinstating the verdict and acknowledging that in this particular case, the defendant's going to get the benefit of Dachenko. So in terms of being, I recognize that a lot of times the judges are motivated by wanting to grant leniency and reduce the sentence, even though that would not be a sufficient basis to do that. That is the motivating factor behind looking to see, is this just so close to being a first degree that we shouldn't keep it at that level. In this case, the defendant is getting the benefit of Dachenko. He's a parole eligible at 15 years. And even in future cases, there is now a difference between a first-degree murder committed by an adult and a first-degree murder committed by a juvenile, and that's taken into consideration with the sentences.
So in terms of our review, do you say that you win unless we would decide that under 33E we would have dropped it to second degree?
Could you say that again? I'm sorry.
Do you say that we basically determine essentially whether we would drop it to second degree under 33E, and if we were to decide that we would not do that, you win?
Correct, Your Honor. I would suggest that in order for you to find it to be properly reduced, you do need to agree with the trial judge as opposed to disagreeing but deferring to her.
So there's no deference given?
In this circumstance, I would say no, because the basis of she applied the incorrect weight to the factors that she considered. So I would say that when you apply the correct weight, you will reach the outcome that it shouldn't be reduced, and there shouldn't be deference to her in that sense.
What is the standard of review generally for a judge who reduces a verdict?
I do agree that there is an abuse of discretion, but when the circumstances are properly weighed. And so, so I guess,
What's
You say she
left
did
of
an error
the?
of law?
I'm
That's what
sorry?
You're saying it's an error of law on her part?
Well, you have to be saying that.
You have
To a certain extent, I mean, I think abuse of discretion is an error of law. I mean, because it
Is, but-
essentially is an unreasonable decision.
But you're saying that she weighed things that she should not have weighed. That's an error. It sounds to me like an error of law.
That's correct, Your Honor. I think it would be both, but correct, Your Honor. If there's no further questions,
All right, thank you.
thank you, Your Honors.
All right. Hearing